Then they say there, Mr. Malema says, there's no justification to stop the EFF from calling for the expulsion of the Gupta family from South Africa. There can be no justification also for the allegation that some threats of violence were made, or for that matter, will be executed. So again, they're failing to acknowledge that that letter makes clear and unequivocal threats of violence, forcible removal. And then again one gets an astounding attempt, paragraph 15 and 16, to attempt to justify what they're doing by again maligning the Guptas. They say because they're so bad, they're free game, we can act like vigilantes, we can be a law unto ourselves, we can target them as we wish, because they charged, convicted, dead and buried already. Nothing more to be said. That's the attitude of the EFF. If we look at 15.1 by way of example, my Lord, it says in 2010, of course that's now 5.5 years ago, Mr. Atul Gupta was arrested by the police apparently for refusing to be searched. And then, my Lord, in a constitutional state, by a member of parliament, makes this, that search is the normal protocol in this country. He suggests that it's normal protocol in this country for police to search people without a warrant. You surely can't be serious. That's why this is a thumbing the nose at the system affidavit. And then look at what he said in JM1. JM1, this is based on a press report. First of all, he says, search without a warrant, obviously because no suggestion of a warrant is the normal protocol in the country. Mr. Gupta was arrested because he refused to subject himself to an illegal search. Because if you look at JM1, that's what the senior prosecutor concluded. JM1, which follows immediately after the signature page of the affidavit, says, the state has declined to prosecute businessman Atul Gupta, who was arrested on the weekend, allegedly for refusing to be searched by the police, his spokesman said on Monday. The docket went to the senior prosecutor this morning, Monday, and after looking at the docket, the senior prosecutor could find no case and no basis for arrest, and declined to prosecute. So as everyone has the constitutional right to do, if a policeman says, I want to search you, and he doesn't have a warrant, and he doesn't have justifiable cause for believing that the person's involved at the time in the commission of an offence, is entitled to refuse to be searched, and an arrest under those circumstances is unlawful. But they have the temerity to raise this, to show what a bad man Mr. Atul Gupta is. And then they go on about all kinds of other things, and the flight into the, which was in the press, for a wedding of the Gupta family and a flight into Waterkloof Air Force Base, and they referred to a report. Interesting thing is I've read that report, I'm not going to spend time on it, the report is annexed. It suggests that certain people should be prosecuted, but no suggestion whatsoever that any Gupta should be prosecuted. The people who should be prosecuted are police officials, government officials, etc., for driving cars without a license, for using state firearms to protect private people, etc., etc. No suggestion of anyone in the Gupta clan who should be prosecuted. But of course, the affidavit says different. Then, of course, if one goes to 16, so I might more or less wrap up there before I just deal with the notice of motion. At this point, and one other point. Lord, in paragraph 16 in the middle, they then say, against all this background, it was for these reasons that the EFF began a campaign to eject the Gupta family from South Africa. The ejection need not be done by force. Well, that's against the meaning of ejection, of course. As explained earlier, it would be perfectly legitimate to start by revoking the citizenship of the Gupta brothers. It would be illegitimate because the jurisdictional facts for revocation of citizenship by naturalization are absent and are not even suggested to be present in this affidavit. And then, of course, if one looks at the article JM3, which I've already referred to, and read the last 3 lines, the last 3 lines, of course, cannot be an honest statement, because the article makes it clear they had diplomatic passports, because they were appointed by some person as an advisor to the government, and then a prime minister decided their services weren't needed. It was only one Gupta and another family member not with the name Gupta. Then they say, Mr. Malema says, presumably owing to the revocation of the passports in Lesotho, the Gupta brothers, the article doesn't refer to more than one, could no longer claim citizenship of that country. A diplomatic passport doesn't give you citizenship of the country. The article says they had diplomatic passports. So this is, with respect, can only be a malicious statement. It can never have been made with a belief that it's true. Then he says there's no reason in law why the same cannot happen here. There's every reason in law because they're citizens by naturalization, they're not holders of diplomatic passports. And then the paragraph 57. The last paragraph I referred to in the affidavit, and I'm just going to briefly deal with those.
Paragraph?
Paragraph 57. That's in response to the statement that after today's hearing, or at or after today's hearing in the Constitutional Court, there'll be a nice surprise for the Guptas. Now, of course, it's conceded, if one reads the affidavit, that it was in fact a sarcastic comment, a nice surprise for the Guptas. In fact, what is meant, that after today's hearing, you're going to be an unpleasant surprise for the Guptas, because you're no longer going to have the protection of the president, and then you're free game for us, because you're no longer got a protection of the president because he won't be the president anymore. That's what's stated, yeah? It says it is correct that there will be a, quote, nice surprise for the Guptas. But it must be understood that the statement started off by the prediction that the EFF will win in the Constitutional Court. The point is simple. Once it has been decided that President Jacob Zuma has violated the Constitution, it will be inevitable that he must step down, or the EFF will campaign for him to leave the presidency. The demise of President Zuma, quite simply, will also be the demise of the Gupta family. It is embedded in the presidency. The fact that the word surprise was used cannot possibly justify the aesthetical nature of the current application. Surprise doesn't mean violence. But in the context, it says, you are embedded in the presidency. The president is your protector. You're getting away with everything because you're hiding behind the president. We're going to get rid of the president, and then you'll see what will happen to you. No one will be able to protect you against the consequences. But no option but to leave the country. That's the message, my Lord. Lord, if I go to the notice of motion, the suggestion is made by the respondent that this means they can't engage in open political debate. My submission is that, with respect to Part B, notice of motion, page 2, paragraph 2, the interdict sought against the first and third respondents jointly and severally. 2.1 is repeating previous or further threats of violence against the personal property of the applicants or any of its employees, in particular for making public announcements inciting imminent violence. My submission that the case for that is made out. In the law 2.2, on consideration, one word should possibly be added. It says interdicting them from interfering with activities of any journalist employed or deployed by the 7th and 8th applicants, in particular be interdicted from conduct or making or promoting any remarks preventing any journalist or investigating employed or deployed by the 7th and 8th applicants from attending events of relevance to the public in general, including but not limited to any marches, gatherings, or, then it says meetings of a political nature. The word public should come in there. In consideration,
meetings of
gatherings or public meetings of a political nature. Obviously, journalists can't claim to be present at a private meeting of the executive of the EFF. But if there's a public political meeting, in terms of the Constitution, if a political party has a public meeting, anyone.
Yes, that I was going to ask you about that, because I mean, If it's a private meeting, obviously they're not entitled.
That's why the word public should come. It's obviously aimed at public meetings. Because the threat is stay away from our rallies, gatherings and meetings. Not our private meetings in our boardroom. They're talking about you better not come near any place where we have an open public rally or meeting. So the word public should come in there because that's what on the affidavit was intended.
What provision of the Constitution are you referring to when you say they're
Well,
entitled?
one has a right to freedom of political association. So
Yeah.
if you're a registered political party and you hold a public meeting, anyone's entitled to a freedom of political association and to be present. It's a public meeting because it's the right to participate openly in political activity in the country. A particular section I can give to Lordship, but that's the provision.
But they go there not to participate, they go there to record what happens there.
Yes, but with respect, it's part of the freedom of speech, the freedom of dissemination of information. It's for the very reason why, of course, we have the press present at this hearing, because there's a public interest in reporting what happens in matters of public interest, particularly matters involving political parties, their statements, their campaigns, their voice for and against what the government may or may not be doing at a particular time. It's a matter of public interest, and of course the reporting of that, it's a public interest matter. The freedom of access to information, the freedom of speech, it's covered by everything. That's why the press always claims with respect to the right to report on what's happening. That's why the press claims the right, for example, if there's a report given by an investigation or a commission to a minister for consideration, claim the right eventually to have access to it, to inform the public as to what's happening. Section 16(1) of the Constitution, everyone has the right of freedom of expression, which includes A, freedom of the press and other media. Now, freedom of the press means the press must have a freedom to have access to information and public events in order to report. Freedom of the press and other media, freedom to receive or impart information or ideas, freedom of artistic creativity, academic freedom, freedom of scientific research. Then the right does not extend to propaganda for war, incitement of imminent violence that we're dealing with, or advocacy of hatred that is based on race, ethnicity, gender or religion, and that constitutes incitement to cause harm. So the same section which deals with this freedom of access to information, and then everyone has the right peacefully, that's 17, and unarmed to assemble, to demonstrate, to picket and present. Petitions, 18, freedom of association. Everyone has a right to freedom of association. 19, every citizen is free to make political choices, which includes the right to form a political party, to participate in the activities of or recruit members for a political party, to campaign for a political party, for cause, and then free and fair elections, etc., etc. Freedom of movement and residence, freedom of trade, occupation, and profession. With respect, the core value of our Constitution is not to muzzle and restrict people's access to public events. Now, Lord, if we get to 2.4, 2.3, submit 2.3 is covered by the papers, that's inciting imminent violence against the applicants or any employees. 2.4, causing damage, directly or indirectly, or promoting damage to be caused. And 2.5, entering or threatening or incite its follows. It should be entering or threatening to incite its followers to enter any of the premises.
Sorry, how should it read?
2.5, I submit, should read entering
Yes.
or threatening to incite its followers, not for incite, or threatening to incite its followers to enter any of the premises of the applicant for any other reason. Then the word than should come in. Any other reason than as bona fide and or for normal commercial purposes. So what it's saying is that you can't enter, you can't threaten to incite your followers to enter any premises of the applicant for any reason other than bona fide reasons and commercial reasons. So it's again not restricting people's right of lawful freedom of movement. Then 2.6, promoting or maintaining any conduct which could reasonably intimidate any of the applicants, including any conduct of propaganda causing the employees to fear for their lives. Again, it's subject to a reasonableness test. They say, well, that they can't say anything. But with respect, if they say something which a reasonable receiver of the information would regard as threatening to their life or intimidatory, it's unlawful in this country of ours. Then 2.7, promoting infringement of the 7th and 8th applicants' right to freedom of expression and right to freedom of press and media to maintain their business of reporting. It's a free trade occupation of being a journalist, a press employee, a newspaper operator. And then 2.8, again, having regard to the fact that on consideration, I wasn't involved at the beginning, on consideration, if they are genuine that they want to approach the minister to consider revoking citizenship, then if they do that in terms of a lawful approach to a minister, putting facts before him to consider the facts and take steps under the Act, then of course anyone should be allowed to do that, but not in the way they do. So 2.8 we suggest, my Lord, should be qualified in the following way. So it's interdicting them from participating in any conduct. Then the word or is again a mistake, it should be to. Participating in any conduct to promote the removal of any of the applicants from Gauteng or the Republic of South Africa. Then I put a comma and say, save in accordance with lawful process.
Just give me the wording again. Participating in any conduct to?
It should conduct to promote. So
Yeah.
the or should be to. And then at the end should come in the words, save in accordance with lawful process.
So it's just to promote in the first line, and in the second line at the end, save.
In accordance with lawful process. So I can conceive that a citizen of a country having information as to why someone shouldn't have been granted citizenship or citizenship should be revoked may be entitled to bring that to the attention of the responsible minister. There's no intention to prevent them from doing it. But what they can't do is saying we're going to forcibly remove you, physically remove you from South Africa. If you don't leave immediately, we can't guarantee your safety. That, with respect, is not acceptable conduct. And then 3, the fourth respondent has stated that they do not oppose and they abide the decision of the court. In other words, your Lordship will see from the finding affidavit the police service has been cooperative in the sense that they've said we'll make a note of the threats, we'll keep an eye on it, if something happens we're prepared to act. But your Lordship's well aware that often what happens is that if there's an interdict and someone breaches the interdict by again threatening violence or picketing an office and saying out of the country, we declare war on the Guptas, whatever they may do. The police, under certain circumstances, may say, this is a civil matter. They haven't yet done anything, they haven't yet hurt anyone, this is a civil matter, and we can't interfere. And that's why, with respect, the courts often make orders such as that, and we don't have any difficulty. We have the word because it's not really intended to that, an order be granted directing the fourth respondent. It could even be requesting the fourth respondent. As long as the fourth respondent, the police, have a request from the court.
So you want me to change the word
Yes.
directing to requesting?
Yes, with respect. Requesting because if the Commissioner of Police has a request from this court to assist in enforcing this order, then that of course means that they have in fact the freedom to say, well, even if you haven't overstepped the line yet into criminal conduct, we can do our duty to protect you from criminal conduct. Because there's a mistake of thinking that the police are only there to deal with crime once it's been committed. The police are obviously there in terms of the police, as you'll see in the preamble, and the Constitution also deals with that. It's to protect the citizens of the country. Lord, those are our submissions, and we will submit to the Lordship to grant the interdict as paid, the cost of order as paid, inclusive of the cost of due counsel. The Lordship.
You're asking for costs on an attorney and own client scale.
Oh my Lord, I don't advance that with any figure with respect. respect.
So
The fact that the
just-
answer has been, in my view, misguided, we're entitled to relief.
so it's just costs.
Yes, just costs, including the cost of treatment.
Right, thank you, Mr. Miritz. Mr. Semenya.
As a Lordship pleases. My Lord, Section 202 of the Constitution of this country says the President as the head of the executive is the Commander-in-Chief of the South African Defence Force. So there's nothing fancy about being a Commander-in-Chief. And in respect of the interim constitution, it was with reference to Nelson Mandela. Why they provoked violence and all of these fanciful things Mr. Maritz is telling us, or your colleague is telling us with respect, is difficult to appreciate. But let me structure for the purpose of response to the public what this case is about. And we'll start by dealing with the agency and deal with whether or not these papers reveal any particular threat and interdict. We'll realize that the relief they are seeking is a final order, and we'll try and examine what the law says in relation to final orders in motion proceedings. We'll examine each of the relief that is being sought in a notice of motion to see whether or not the case has been made out for it. And lastly, we'll deal with the question of cost. But my Lord, I think at the very outset, what must be said is the following. Law will tell us context is everything. You are being invited in this application, my Lord, to interdict a registered political party in an electioneering year when it seeks to canvass seats in democratic institutions of government, in parliament making. You are being invited to say they cannot say the group does not go. What type of democracy is this? You can't say in an electioneering way that Guptas must go. But the Guptas are no Joe, you know. Your Lordship can take judicial notice of a very notorious fact about the repeated allegations in all of our media about how intimate they are to the head of state and how that intimacy is wrong and how it undermines the country and how everything else is that. So by association, they can't be the ones surprised if they're going to become part of political game in an electioneering.
Mudslinging.
It's mudslinging even before the Constitution. Our courts are full of judgments that say if you're going to play in that political space, you must then develop a thick scheme to deal with that environment. They're not saying they don't have any association with the power of this country. They have never denied that. And it is common because, as I'm saying, the Lordship can take notorious judicial notice of a notorious fact about their standing in particular in relation to the political landscape of this country.
But the argument is that they are being threatened with violence.
Well, I'm going to go to that and see. As long as we understand the context,
Yes.
that we are talking about an election year, we are talking about the right of a political party, we are talking about their right to campaign, we are talking about their right to solicit their voters, they have the right to pick a parliamentary seat wherever they win the vote. That's the context within which this happens. It's not in an ordinary year about A and B discussing or talking about each other randomly. Now let's investigate first of all the question of evidence. Your Lordship will see the case for LMC is sought to be made in paragraph 100 and 101 of the following affidavits. with everything happening, my papers I see have not been translated, but it is paragraph 100. It is imperative for the applicants to take urgent steps to prevent violence, and to the extent that there is a march for members of the second respondent on 9 February 2016, it is reasonable, of course, and they don't tell us why it is reasonable, to expect that violence will emanate from the march. We have had a march. There was no violence. Even the very predicate on which this application is launched is missing. It has been demonstrably shown there was no violence, there was no reasonable belief to expect that the violence.
Well, doesn't that paragraph say two things? It says it's imperative for the applicants to take urgent steps to prevent violence, and then it says, and to the extent that there is a march for members, it is reasonable to expect that violence will emanate from the march.
Yes, but the first premise, if it is to prevent violence, you must go and establish what reasonable apprehension of violence do you have. Have you established it? And once we know that, then it would be reasonable to go for an interdict relief to prevent that violence. But I'm saying, let us deal with the second one, which seeks to suggest that there was going to be violence. And let us then measure whether or not their assessment of the situation is sound or rational. And we're making the submission that there is nothing rational or sound about it, but we propose to demonstrate it to your worship. Let us look at the paragraph that follows, which is 101. As a result of the aforesaid and the imminent threat of danger, now this was imminent this month or yesterday when we were circulating us, we now know there was no imminent violence or threat of danger. Together with the promise that there will be a surprise for the applicants on 9 February 2016, this application could not be brought at any later date than the morning of 9 February 2016. Is that correct, Madam? As I understand the party's directives in this court, urgent applications are to come on Thursday or a Tuesday, properly paginated, etc. If you are entertaining an agency of a nature that requires two things to happen, that you will send your papers on the 8th in the afternoon at 14:45 and expect notice of intention to oppose to file at 1500 hours. Now, this is the nature of the agency that the respondents have been placed under. Not only that, you are said you must file your answering affidavit an hour after that. That's the nature of the agency that you have been submitted to. And I can show you, Lordship, it is exactly at the notice of motion. On page 2, I don't know whether it will be page 2 of the Lordship's paginated papers. They say, we need to take notice that this application will be heard in this honorable court on 9 February 2016 at 9 o'clock. Not 10, 9 o'clock. So it also even goes outside the ordinary hours of sitting of the court. It says this one will be at 9 o'clock, and this is what you are supposed to do if you intend to oppose the relief.
Well, Mr. Semenya, obviously yesterday, the intended march was still, on the applicant's version, part of what they feared would result in violence, and more particularly violence against themselves. But when the matter was called this morning, and I indicated that I thought that the matter should stand down to tomorrow for argument, your clients were not prepared to give an undertaking that until tomorrow there would be no violence. And for that reason I said, well, then we'll deal with the application this afternoon, because the applicants wanted some assurance in the form they asked. They commenced asking for an interim order until tomorrow, and I then mentioned the possibility of an undertaking which your clients were not prepared to give.
Indeed, my Lord, the respondent's position 1 to 3 is that they are not even entitled to, in this court, if the rules of this court apply properly. They are not supposed to an interim order because they have made out no prima facie case for an interim review. They are not entitled to a final order because they have not made out a case for a final review. So they could not get an undertaking in our submission. They could not get an interim order in our submission, and neither are they entitled to a final order. But we go back and say, assuming that was their mind frame, surely when no violence occurred at Braamfontein as they anticipated it would, they would come back to say, mea culpa, perhaps our reading of the environment was wrong. But they persist with an order that says, give us a final order interdicting the respondents from A, B, C, and D. Now we ask the question, are they inside the court on agency to start with? Those are the two bases on which they are seeking to persuade your lordship that this matter is urgent. And they talk about that threat being imminent, but they don't tell you why it is imminent. What is it that has happened on the part of the first three respondents that renders them to reasonably hold an apprehension that is reasonable, that the threat is imminent? And secondly, what type of threat is there? What violence are they anticipating would happen? Because we'll be able to respond and say, well, you're expecting us to attack in Cape Town, there won't be anybody in Cape Town for the EFF. Or you expect us to attack us at a particular point, there won't be anybody there. So we are unable even to answer properly if somebody says, as I will demonstrate with all the other passages. When somebody just gives you a blank statement, we anticipate there will be imminent violence or threat of danger to ourselves and to our property. 102, so says the applicants. The safety of the applicants, its property and its employees is paramount. And that is why this application is launched on an urgent basis. That's a conclusory remark. Your Lordship should be asking, where is the evidence that supports this conclusion? We want to go and look at that evidence and say, having assessed this evidence, the conclusion which comes in paragraph 102 is sound, is rational, is based, is reasonable. There's no evidence to support it. It's just a conclusion of the informant. But anyway, I may be wrong. Let us go and look at 68, which begins to want to explain why we're having this application on it. That is now paragraph 68. On page 24, I don't have a combination, I apologize for that. But there is a heading that says, what happened since the threats emanated? I'll deal with whether or not there ever were threats. But they say they want to tell us what has since happened. Some of the executives of the applicants started to receive threatening phone calls as from Monday, 8 February 2016. Do they take the court into confidence who these executives are? What threats these executives received? What was the nature of the threat? Nothing. Then we ask the next question. Do they give us any confirmation affidavit of a clear hearsay statement like that? No. There's no confirmatory affidavit of some of those executives who are telling us that they received threats, and from whom, and what was the nature of the threats. Silent. Let's go to 69. One of the executives at VR Laser Services Pty Ltd started to receive threatening phone calls as from approximately 2:30 a.m. to 3:30 a.m. Who is this executive? Have they taken the court into confidence of telling you that this is the executive, this is the nature of the threat, it was a verbal threat, this was the language used, it is a language which your lordship would reasonably reading would conclude it is a threat against life or it's a threat against property. It's not there. Again, it's a hearsay evidence. Do we have any confirmation for it? No. Do we know who that executive is? No, we don't. Mr. Peter van der Merwe received various phone calls, and after taking the call once or twice, 17 missed calls followed. The affidavit you have of Mr. Peter van der Merwe, it's a blank confirmatory statement that says, I confirm the contents of this affidavit insofar as they relate to me. He's not telling us what threat they were. where were they coming from, what were the nature of the threats, at least those two ones that he says he picked them up. So again, we're using this language of threat, incitement to violence, this and the other without giving the underlying evidence for it.